Good afternoon again. Thank you so much for joining us. We have Zane Uriberry leading today's Stop Kite from Blowing Away with Impairment. He always has the best webinar titles. Maya Tola is guest starring to assist with questions today. Thank you both so much for being here. Maya, do you want to start us off?
Sure. Hi, everyone. I am sorry you guys are not able to see me today, but my name is Maya Tola. I am with the LA office here at Bradford and Barthel, and I am excited to help Zane with your questions. During your sessions, I'll be fielding your questions to him, so feel free to drop them in the chat, and we'll try to keep it interactive and do our best to get to as many of them as we can with the time that we have. I am also currently wrangling, I should say, a 4-month-old Dachshund puppy. He didn't want to listen to or learn about kites, so he is not in the room with me. Don't worry, we won't hear the barking, but you should know it's happening. But yeah, in the meantime, we'll keep the questions coming and we will help out.
Thank you, Maya. Okay, Zane.
Hi, good afternoon, everyone. My name is Zane Uriberry. I'm in the Ontario office of Bradford Barthel, and I'll be going through and doing some training today on Kite and some things that are happening with trying to move permanent disability around and make changes to it. One thing, though, I did want to also mention, though, before we get started, is that we do have a wonderful rating department that we utilize internally. You can utilize externally as well. Not only do they do a great job of rating, but if you go check out the blogs, they also write blogs and they do a fantastic job of laying things out and getting all of the information down that we need when it comes to doing different types of ratings. So I would just want to mention that. So here we go. We're going to talk a little bit about changes to permanent disability and the determination of permanent disability that began essentially with the Kite case itself. Permanent disability rating schedule is, of course, presumed to be correct, but that really hasn't stopped a lot of action to try to get it changed, whether or not it can be changed legislatively or through the courts. And the things that we're looking at today are essentially changes that have happened through different court decisions. This new rating schedule, and in fact, the whole AMA guides has been around now for about 20 years. But in that time, we have seen a number of cases that have come down that have either tried to expand their way out of the AMA guides, move around within the AMA guides, simply not use the process at all, or make some kind of change to what was laid down in the labor code in terms of trying to determine what permanent disability is. We saw this with Ogilvy. We've seen it with the Alvarez case. We definitely saw it with the Guzman case, and then we have seen it with Kite. And at this point, we've kind of been, we went around for about a decade with the Kite case and some other decisions that made it difficult to figure out when are we exactly adding impairments together? When are we combining them together? What's the standard? What's the criteria? What kind of evidence do we need? And so we're going to kind of look at that, the history of that, how that's developed, what the current law is, and then, of course, some strategies that will help in terms of trying to figure out what is it that you need to do with a case now as the law currently sits in order to make sure that permanent disability is not just radically increased because of the changes that can happen due to the Kite and, of course, later on the Vigil case. But as we kind of look at these cases, what you're going to see mainly is that the court is really doing their best to try to find a rule or explain something to help guide judges to make these determinations regarding impairments and how to add impairments, or if they even shouldn't do that. And part of the difficulty was we really didn't have a lot of guidance in terms of some kind of en banc decision from the WCAB for about 11 years after the Kite decision itself came out. So it was being interpreted a lot by the judges on their own from some WCAB just panel decisions, but those weren't always consistent as well. So we need to kind of focusing on the reasoning of the judges, what the judges were actually looking for. At the trial court level, of course, they were looking at medical reporting that was being used to justify changes in the permanent disability schedule. So we'll look at some of those kind of things as we go along today. But the court was constantly bringing up and emphasizing when things would go up to the WCAB, this whole idea of substantial medical evidence. And of course, substantial medical evidence is one of those things when you hear that phrase and you hear it thrown around constantly, but we have to look at what's actually required for it. And we'll see that here too in one of the slides. since we have to, that's a starting point here on these cases, whether or not there's going to be a deviation from anything that is laid out in the permanent disability rating schedule, there has to be substantial medical evidence to support that particular change. So that is something that is absolutely going to be necessary. Of course, that comes from a doctor. And in this particular case, what we'll talk about is whether or not you then get to add in based on that. Okay, so ultimately, kind of looking at the Kite case itself, it's a bit of an expansion of the Guzman idea that we're not going to be that strict when we're looking at the guides themselves and how ratings are actually being done. So let's look at the Kite case itself. It's Athens administrators versus WCAV and sort of what some of the facts are of this particular case. It seemed like it was a relatively straightforward bilateral case where the individual who was the applicant had 20% impairment on both sides, but it also had bilateral replacement. And so there was some indications from the doctors at that time that the applicant wouldn't have the ability to compensate for the injury that they had on one side of their body because they didn't have a, quote, good hip on the other side of their body. And so this idea then began to develop that if you have two injuries that are kind of working together, we're going to look at possibly increasing permanent disability in that particular case. Because given sort of that lack of ability to compensate, the doctors in that particular case were looking at the injury and saying the injuries are kind of working together, and it does appear that impairment is higher than it would be under normal circumstances. And so this is where we end up with this wonderful phrase, synergetic effect, which we also sometimes you may see it in other decisions or referenced by other doctors as an inability to compensate or increased impairment due to inability to compensate, or that that wonderful phrase, synergism, which it honestly sounds like some political philosophy that you may have learned in college. So it's an interesting phrase, an interesting word, and as a result of this case, largely what we ended up seeing was the word itself just getting used. So we did have to end up getting used to that. The idea that doctors were just going to use the word, synergetic effect, or there's synergism here between these two body parts, and that's going to go ahead and that's going to justify any kind of change in impairment. We're going to go ahead and add the impairments together rather than using the combined values chart. One thing to remember, though, when we're looking at the permanent disability rating schedule and impairment here, specifically in Kite, is that they're attempting to add together impairments that are from different parts of the body, but for the same date of injury. So that is something that you do want to keep in mind. Nothing going on that's expansive in terms of trying to add together things from different dates of injury or add different types of injuries together, because those are all being rated, of course, separately. Those are being handled as separate and different claims. But it is something that I want to point out because I do see even applicant attorneys making that mistake during cross-examinations. Usually this will happen if someone has a specific injury and a CT where the CT ends on the same date as the specific injury. Then all of a sudden things start to get muddled a little bit, but those are two separate and two different claims. And what we're talking about here is combining impairments or adding impairments together that are from one particular injury. Otherwise, it's going to be a Benson issue, of course. If there are two different dates of injuries that are going on, there's going to have to be apportionment, there's going to have to be a split out there. The causes of permanent disability have to then go ahead and be determined. So the workers' compensation judge in the Kite case, he says that it appears that it was logical that a person who is able to compensate through the opposite member for an injury to one limb is to some extent less disabled or more impaired than someone who cannot so compensate. And so the judge was actually looking at this and saying, that's kind of reasonable in this particular case. And because of this, because we can find a reason to do something different, we're going to go ahead and say that this portion of the guides, this standard and this way of determining impairment is itself now going to be rebuttable. So the question then came up, this was appealed, the appeal was not taken, but it was then what is now needed to rebut this presumption? What do we then have to have in order to actually go, okay, well, if the permanent disability rating schedule is presumed correct and we can rebut it, what do we actually need to do that? And so that's a bit also of what we're going to end up getting into. It's important to, and some of this just may be my commentary, but it's important to remember that Kite's focus was not really on the accuracy of permanent disability, but it was on more permanent disability. And really, what do I mean by that? If the focus was on accurate permanent disability, then it would have allowed for reductions in permanent disability for individuals that met certain standards, so that they say, if you looked at a strict reading of the AMA guides that came out at 20%, but when you looked at their activities of daily living, they weren't really impaired at all. So there would be a reduction. But everything that we see is always an increase in permanent disability. The change is always going up and the change is not going down. So words that, and as I pointed out before, the words that you often were seeing and that you will still see to this day are synergism, of course, non-overlapping, now that we have the Vigil case as well, and an inability to compensate. So those are the words that end up being used when they're trying to not utilize the statutory rating methods that are available. So what are kind of the mechanics of actually using Kite? And I wanted to put in, just for reference, so you had it, it's an example, it's a fairly just straightforward example that you can utilize and you come back to. I thought about putting in more complex examples, but I didn't need to put in the ratings because the ratings are going to be the same. This isn't affecting the actual rating, it's affecting the combination of the impairments themselves after the fact. So if you have two different body parts that are injured in the same date of injury, and you have permanent disability that's 10% and permanent disability that is 8%. There's a combined values chart. We've all had to use that when doing ratings. Follow one number, follow the other number, and you're going to find a number that meets. And that's going to be your level of permanent disability for those two individual disabilities that are there. Under Kite, the idea was, let's not use the combined values chart. Let's not go with any of the adjustments that have been made in that chart. Let's just add them, because adding them together is giving us, it's frankly giving us a higher number. There's a little bit of something different though too, that the combined values chart was designed with the idea that it is taking into account some overlap of disability, or some idea that there is not as much disability with a second injury as there may have already been with the first. So if you have disability in one body part and disability in the second body part, the idea is that you're not disabled. It's the sum is sort of less than the parts is essentially what it is. And so there's this mathematical formula that they utilize, and that's why 8 and 10 combined together in the combined values chart for set to 17, because they were actually trying to take account of some of the overlap that may actually happen in impairment. This is the combined values chart itself. Always nice to just have it as reference and something to see. You will see though that some of the numbers on the combined values chart are also what would happen if you added something together. My best example of this was an applicant attorney who took a cross-examination of a doctor and went on for 20 minutes until he finally got the doctor to admit that it would be better to add the impairments together rather than combine the impairments together. And the problem was once the deposition was done, I pulled him aside to talk to him, and I said, I didn't want to stop you in the middle of it because I wanted to honestly see what the doctor was going to end up saying. But the two numbers that you were doing were 8 and 8, and they go to 16 either way, if you use the combined values chart or if you add. So you were getting the exact same number. So sometimes it will come out to be exactly the same. In those particular cases, there really shouldn't be a battle here to try to do this, because this is a fact-driven and a very fact-intensive sort of analysis, which is why you will see that this is used on either higher value cases, or it's going to be used on sort of those older cases where the multiple injuries have now come up. And maybe it's even creeping up toward life pension. And it's only the combined values chart that's kind of keeping it down. And you start adding those impairments together, suddenly, all of a sudden, the number's getting closer and closer to 100%. So that is something else that is.
Hey, Zane.
Yes.
So I have a question for you. So when there are two different injury dates, you can't add them. Could you confirm if they're separate, that they are separate rating strings, or can you add them and then you are making a determination on apportionment?
If you have two different dates of injury, then it's handled differently, because
Right.
each date of injury itself is going to have its own separate rating. If you have a common body part between them, if both of them are the back, yes, there's going to have to be some determination as to what is apportioned to one date of injury, what is apportioned to a different date of injury. But there should be no use of the Kite and the Vigil combination system that has been come up with. That should not be used when you have, a date of injury of 2015 and a date of injury of 2024. So that really is to be kept separated.
Okay, thank you.
So that's the Kite case, and that's essentially what we ended up starting with, and this whole new idea of, well, let's add the impairments together rather than combine them. Maybe it will provide for something that's a little more accurate for this individual's impairment. And of course, there's great difference of opinion as to whether or not that's actually what was going to end up happening. So then we ended up, of course, with a variety of different cases that tried to go down different roads to add up impairment in different ways. And we'll start out here with the Sweetman case. In this particular case, we really end up with sort of this mixed bag. And it was interesting that this didn't actually become what the rule was. But the applicant here had a back injury, which is orthopedic, of course, a left wrist injury, which is orthopedic, and then a sleep disturbance injury as well. So all of these particular injuries in this case, they were trying to add them all together and determine, whether or not can we do that? Would that be more accurate? And there was a determination made, hey, it looks like the combined values chart really isn't fair when it comes to this particular claim and what this particular person has. What the court ended up doing when they looked at it is they went, okay, well, we've got to deal with this issue sort of overlapping impairments. So we can find that the back and the left wrist, those do not overlap. So if there's no overlap in the injury, we're going to go ahead and allow them to be added together. Okay, that's great. So we're going to add those. But then the sleep disturbance arose because of the individual's back pain. And it was determined that that was a complete overlap. And so it essentially said, well, we're not going to allow addition in that particular case. Since there is this overlap with the back pain itself, we should use the combined values chart and determine permanent disability that way. This is an interesting case because you have half addition and you have half combination. It's very different, not only from what Kite had been talking about, but also from what has essentially kind of happened since. However, you can see this happening and justification for this happening going down the road. One interesting thing though to point out, of course, if a compensable consequence exists, by definition it overlaps, and so by definition it should not be added. The impairment should not be added. But also today, since we do have some restrictions on compensable consequences, particularly sleep, particularly sight, those should not have any permanent disability falling on them at all. So there shouldn't even sort of be that particular debate. Do we need to add or do we need to combine? But the key here is that there was this initial discussion of an overlap between two different injuries, between the sleep injury and the back injury. And that's going to kind of become key as we begin going through the rest of the cases and looking at the rest of the cases. So when we look at the lot spike case, this one was interesting because there were two AMEs. We don't usually like to use AMEs, but here we are with the case. They discussed the actual interplay between the psychiatric component of the applicant's disability and the orthopedic component of the disability. But the WCAB ended up finding that really neither of the physicians provided an opinion regarding whether or not the impairments would be more accurate if they were added or if they were combined. So essentially what they were doing is there was no explanation as to why it would be appropriate to use addition from a medical standpoint. And there needed to be some kind of explanation for that. And so this is an example of where, there was this finding that there was not substantial medical evidence, which is absolutely needed if you're going to provide the permanent disability rating schedule. And I do want to emphasize that the substantial medical evidence is something that the applicant is going to have to come up with, because they're the ones that are attempting to use this and to rebut the rating schedule itself. So it is going to be on the applicant to kind of develop the record to the point where there is a solid medical base, and we'll see cases that had that, a solid medical basis to go ahead and make that deviation. So whether or not you're talking about Alvarez Guzman or you're talking about Kite, there has to be that substantial medical evidence, a medical basis in order to change, rebut the permanent disability rating schedule, and then do something different. So this case is a bit in contrast with another case that came out, the Tania case that came out about 2 years later, where the board stated that the combined values chart was not needed if addition of the permanent disability itself provided an accurate rating. So again, but that was a case that also had an orthopedic AME and a psychiatric AME. And they found that the impairments themselves did not overlap. And they thought that adding was better than combining because they got a better, more complete picture of the applicant's permanent disability. So when we see this as one of the first times where there is some kind of lack of overlap, but then there's going to be an addition here. The focus had previously been on synergistic effect, right? Is the one hip can't help the other hip, and there's some kind of interaction that's going on there. And that had been something that had been looked at in addition to activities of daily living. But here really it was, is there any overlap in the impact on the activities of daily living? Oh, there's not? Okay, well, I think that we can go ahead and we can do an addition in this case rather than simply using the combined value charts. We then moved on to the Barilla case where the WCJ, the trial judge in that particular case, went ahead and allowed the addition, but they did it in sort of a strange way. They instructed the DEU to go ahead and add rather than combine a number of orthopedic claims along with the psychiatric disabilities. And so this went up on reconsideration, and the WCAB ended up saying, no, this is going to be different. We're not going to hold this the same as the Kite case. There's insufficient evidence again as to why we're adding rather than combining. The idea that it would be more accurate and it would describe overall disability better really does have to be explained out by a doctor. So there needed to be a detail what they call how and why. There needed to be a better explanation as to why it was that we were doing the adding rather than the combining. So that discussion was actually needed. And it was nice because this kind of provided us with a little bit of a theory that could be employed with medical legal evaluations and doctors' depositions and trials. If there's no synergistic effect between the two disabilities and no adequate explanation for why we were not combining and why we were adding, then you'd be able to go ahead and say you haven't rebutted the permanent disability rating schedule. It needs to be used as is.
So, Zane, from a defense standpoint, when you're assessing whether the Kite doctrine has been properly applied, particularly in cases where impairments are, so when cases are when impairment is added instead of combined, what specific language or medical reasoning should we be looking for in the report to see if it's truly justified? I know you mentioned not just synergistic. What would you be looking for when it comes up for you?
Yeah, so the exact language that you would want to end up looking for, I am going to, if I can, find that slide, which I can. And we're skipping a little bit ahead to Vigil, but this is essentially that third bullet point is going to kind of give you what you are looking for. It has to be framed in terms of reasonable medical probability. It can't be speculative. Based on pertinent facts, and there are a lot of times that we don't have anything that a doctor is saying that's based on actual facts. We will see determinations that are made later in a QME report, and you go back and you start looking at measurements and you start looking at what some of the evaluation was, and you can't find any facts that move the individual into the position that the doctor is then putting him in, the category that they're putting him in, the DRE level that they're being put in. So pertinent facts have to be there based on an adequate examination and history, and it has to set forth the reasons supporting its conclusions. And the reasons supporting the conclusions are honestly a lot of what ends up being missed in a lot of these particular cases. When they say it's not substantial medical evidence, that's because you haven't provided the reasoning behind it, why all of a sudden we're changing what we're doing and we're going somewhere else. So that is something I would definitely look for. If you are trying to essentially challenge, what the doctor is saying, or you want to say to the doctor, I'm going to challenge your determination of this. I think there are a number of different questions that can be used that you would end up using when you're questioning a QME, because you want to start to get into what is it specifically about this case that is making it so that we should be adding rather than combining. We'll see at some point that you can actually end up in a situation where you have two individuals that have one has a shoulder injury and an elbow injury on the other side, but so does the second applicant, and they can have exactly the same loss of range of motion. But because the ADLs are more affected on one than the other, you could see a situation where the permanent disability kind of changes. And then the question becomes, what specifically is being changed about those activities of daily living? So those are questions that you would, of course, want to pose to a QME in order to get some clarification on that. What specific ADLs this back injury affected you don't see in most cases? Why is this case above and beyond a normal case? Why is it different? Talk about the stated level of impairment. Does it meet with the objective findings in the diagnostic testing? Because the more that you can show that it's in line with what it's supposed to be, then the more you can show that the permanent disability rating schedule itself has not been rebutted. So that's essentially where I would end up starting with that in order to determine whether or not the QME's reporting has been done correctly. Does it contain all the elements from Escobedo? Does it contain all the elements that it needs to have in order to be substantial medical evidence? And then if it's going to be challenged, if applicant attorney is trying to challenge it, you've got some tools to go in there and talk to the QME during cross-examination and then try to get that particular determination itself changed. Okay. So I'll skip Diaz real quick just to let you know whether or not it's a medical determination or a legal determination. It is a legal determination, but it does have to be based on medical facts. So that's why those medical facts are going to be so important, because again, the court just says substantial medical evidence. We see that come up again and again and again in these matters. The courts have also, in some of the other cases, the Leo case, they were talking about the fact that it's the explanation that makes a difference. Don't just say, well, look, we've got connected areas of the spine, neck, and lumbar. It's not. We need something that is very accurate, that's telling us why, in this particular case, we should be adding rather than combining. Why is this a different type of case? Why is this something where there should be some kind of variation or differentiation? So definitely something to look at. It's not simply a case of, did the doctor give, some kind of explanation? It needs to be a detailed and accurate explanation, because they are attempting to rebut the entire, essentially the AMA guide system that has been put in. They're taking a piece of it and saying, we don't have to follow that. And if you don't have to follow that and you have to rebut something that's presumed to be correct, that's quite difficult. And any of you that handle any kind of cases that have to do with public entities, police officers or firefighters, there are presumptions that are there, and rebutting those presumptions, of course, is quite difficult. So if a presumption is getting rebutted here, it would also stand to reason that it would also be quite difficult. In this particular case, we're looking at a situation where there's a lack of synergy, essentially, between the two injuries, and there was really no need to add them together. But the medical reporting found that there was no overlap between the, again, orthopedic complaints and psychiatric complaints. And so there was really a lack of interplay between the impairments. And the lack of interplay between the impairments was something that we actually used for quite some time because it was a helpful thing for us to be able to understand why is it that we don't have to add these particular impairments, why is it that we can simply combine them. And so we ended up kind of getting into a newer line of cases here where we were looking at whether or not not necessarily whether or not you compensate for it, but what was kind of the interplay between the two events there. Many cases also would just be very blunt and straightforward and say, look, the great weight of authority holds that you have to use the combined values chart unless you have some kind of substantial reason to not do it. And we did end up using, you'll remember probably there was the Kite case and then there was the Fitzpatrick case before there was Vigil, talking about what exactly was needed. And this is really where we get down to that, substantial medical evidence. The board did not want to be making these ad hoc decisions, trying to go around an entire system to determine permanent disability that had been set up. They didn't want to allow each judge to kind of make their own decision and own determination when it came to impairment. There definitely needed to be some consistency between that. So not only, substantial medical evidence looking at the overlap, and there needs to be an explanation as to why it is being used. So at this point now, we were starting to get a little bit more consistency in the opinions and in what was coming down as to what exactly needed to be done in order to rebut the presumption. And we end up getting cases, where you were allowed to use Kite, you were allowed to rebut the presumption, but there had to be that detailed again how and why analysis that was coming from a doctor. And we did get that in some particular cases. And then we got other confusing cases where we have an internal A&E who took hypertension and then they added it to the orthopedic claims. And they did so because they said there's no overlap between these particular injuries. And the judge went, you're right, there's no overlap, so you should be able to do that. And the board again said no, because there wasn't any evidence to prove that what was happening between these two injuries was increasing impairment. The person was not worse off simply because they had two injuries that did not overlap. I will.
So I have another question for you, Zane. Would the doctor indicating that there are adverse effects on the ADLs, the activities of daily living, be sufficient to support Kite?
Well, that's one thing that they're going to have to do, but they're going to have to explain why the ADLs are being affected and what exactly is causing the particular ADLs to be affected. Because sometimes it's not going to be the interplay between the two different injuries. Sometimes it may be something that's non-industrial, which you always want to be looking for. And sometimes it's simply a result of one of the injuries and not the other. But that is definitely a component that has to be in there. The doctor does have to talk about it. Because when we were then trying to say, whoa, we don't want you to use Kite, and we go in there to try to get that decision reversed or prevent it from happening, that's one of the things that we're focusing on, of course, is that the individual's activities of daily living. Because that's really the best way for anybody to figure out what exactly is going on in a particular case. Is what is this person actually able to do? What do we see that they are capable of doing, and not just what they're telling a doctor. So what we're doing when we're looking at the ADLs and when the doctor's talking about the ADLs in there, it needs to be fact driven. So it needs to be something where the doctor has factual information, and so that's going to come from all kinds of outside sources. It's not really going to come from the doctor observing someone in an exam room, because he can't see if he can move trash cans, if he can carry groceries, if he can mow the lawn. That kind of thing is not really being looked at. So that's where further information from depositions is important. Sub rosa in this case becomes very important. It becomes something that you really, really want to have, especially in cases where the ED is getting higher and higher, and it becomes clear that if you're adding it together, it's not just going up 1 percentage point or 2 percentage points, it's going up significantly, getting into that life pension kind of area. So that is something that you would definitely always want to be looking at, is the facts that you can provide to the doctor so that they can actually see how that the ADLs themselves are being affected. So, I mean, that is really, one of the takeaways is what's the best way to do that? You've got to provide the doctor with facts because the doctor can only make the determination, based on the information that they are being given.
Okay.
So we've seen kind of what the courts have been saying about all of this, but we have to kind of go back and go, oh, wait a minute, wasn't there something else that was talking about this? And yes, the AMA guides themselves and how to use the combined value chart, and it's laid out right there. How, the method for combining various impairments is based on the principle that second and succeeding impairments do not apply to the whole unit, but only to the part of the value that remains. The easier way of saying that is that the second injury isn't making you as disabled as the first injury did because you weren't whole to begin with. And essentially what's going on with the Kite case and with the Vigil case is that that entire conclusion that is in the guides is being challenged. They're saying, look, that may not be the case. If you have one injury and a second injury, you might be worse off. But it is also possibly the case, as the guides breaks down, that one injury and then followed by another injury may not make you as injured as adding up all of those injuries together. But it is interesting that the guides actually speak to this exact point and actually talk about it and actually have something to say that is worth hearing. And it is something that can also be used because since these aren't presumed to be correct, they can be used when making a case, when arguing a case in court or arguing a case in cross-examination with a doctor. So we had all of these different cases, but there wasn't a lot of guidance, that was happening. And that became difficult because it would kind of depend. Well, if I have good medical evidence, then do I have to have overlap? Do the two injuries have to overlap and cause problems to the same ADLs? Do they have to have no overlap whatsoever? Do I have to have increased disability? What do I exactly need? And so that's when the Vigil case came around, and it was finally the WCAB's turn to stand up and go, okay, here's an en banc opinion, here is something that's going to be controlling, and here's something that we are going to give you for guidance. So it's, rebutting the permanent disability rating schedule and saying that it can be rebutted, and it's an expansion of the Kite case itself. I will tell you that applicant attorneys were very enthusiastic when this case came out, because I was in a cross-examination, I believe within 48 hours of this case coming out, and an applicant attorney was holding it up on Zoom and saying, "Doctor, have you read this case?" And I'm looking at it going, I don't know that any of us have read this yet, because I don't think it's kind of been circulated yet. But no, it was definitely a case that clarified what the rules were going to end up being. So there was justification for the excitement, at least. Now there were going to be some rules that have been laid out and some guidelines that we were going to be able to follow. With the Vigil case, though, you essentially have two big ways to win big. You have to look and see if there's no overlap between the activities of daily living between the injuries to different multiple body parts, then you're going to be able to add. And if there is overlap between the activities of daily living, and the overlap increases or amplifies the actual impact on the ADLs, then you're also going to be able to go ahead and add it as well. So they kind of gave us two different ways of doing this. And previously, there hadn't been this kind of delineation into, well, here are the circumstances in which you can go ahead and try to add impairments together instead of simply combining impairments together. So it was good to have some kind of clarification, but at times it can get to be a little bit confusing, because if you remember, and if we go back and we look at some of the other cases, while there wasn't substantial medical evidence, there was also issues where they said, hey, look, you can't combine those two because there's no overlap in them. Orthopedic injuries and psychiatric injuries. And so you can definitely see how there would end up being confusion between looking at the old case law and what you could do, and now looking at the new case law, trying to digest it and trying to figure out, okay, so, what are we going to do here, and what are we going to go ahead and focus on now? And essentially what we're focusing on now is activities of daily living and how those are impacted by the underlying injuries themselves. So This, of course, does make the determination of whether or not there is going to be, a change very, very fact dependent. So we did hit this slide before. Do just want to hit it again, though, that you're going to have medical reporting, that is very complete, that is not guesswork, that is not speculatory, and that does not simply use the word synergism, synergetic effect, or synergy. That's simply not enough. It's clearly not enough based on the case law, based on what has been said, but there has to be some concrete basis to get here. There has to be a factual basis in order to say, hey, you've rebutted the permanent disability rating schedule. So it is difficult because the entire schedule that we have was designed to a certain extent to deal with overlap. And so, dealing with overlap is, if it's already built into the system and saying, hey, there's an overlap in these injuries, it's causing increased impairment. We did attempts to deal with that, at the time that the entire guides themselves were created. So something else to think about there. Do want to, though, continue to emphasize, since this is a fact-driven analysis, that the facts that you need to get and present, especially for activities of daily living, to give it to your QME. Not only will that help in avoiding issues with Kite and Vigil in terms of changing the way that the impairment is being evaluated, but it may also turn around and help the way that the impairment is even being looked at, because if you do have someone that all of a sudden you have video of that has a different range of motion, we all know, hey, that can change the category that you're in. That can change your overall level of impairment. And the investigation in these particular cases can actually bring the impairment down, not because that's what we set out to do. We just set out to stop Kite and stop the adding together of impairments. But what we ended up doing was finding ways to actually reduce the permanent disability itself. So, what do we kind of think about this entire thing and rebutting the presumption that the permanent disability rating schedule is correct? It usually is an attempt to just increase the value of cases. It's usually just a chance, in a sense, to get more money. But it kind of stands for the proposition that you're going to be able to get additional permanent disability if you get everything to work correctly. But the vast majority of cases, there should not be a change in permanent disability. This should not be something that is used constantly. This should be something where there has to be a great justification. If you remember any of the language that was used in Guzman, where it had to be an extraordinary case. And in these particular cases here, when you're using Kite and using Vigil, this should also be something that is not as likely to be used as the regular rating system. The regular rating system should really continue to be used as the primary method in order to determine impairment written into the law. It's statutory, so it's something normally you would expect judges to follow. But I understand what it is that they're doing as they're attempting to go. We do have cases where it does look like the person is impacted more by the same disability. And so how do we end up accounting for that? That's just the real reason that all of this comes into play. This also comes into play because you'll end up with a number of injuries from one date of injury. So from a single date of injury, you end up with multiple body parts being injured. And usually these are on the older claims, and these are on the claims that have been around a bit longer, where additional body parts tend to pop up as being injured or as to having the problem, maybe a longer CT of some type that ends up having this kind of thing. So it's cases that have multiple body parts that are injured in a single injury, or older cases. And the problem is, on those kind of cases, those are the ones where you would use Vigil and Kite, and those are the ones that are most likely to try to reach 100%. So, attempting to resolve those cases to the best that you can, is always a good idea. Another thing, though, that you can do, with those kind of cases, though, is generally, especially on the long-term CTs, we find this out a lot in depositions, is that the worker probably had some specific injury along the way. There was probably some other type of injury that happened. You find out there was a fall, there was something that wasn't really reported. But sometimes you can take these other injuries, and instead of having 5 body parts injured on a single CT, you end up with two smaller specifics and then one CT, and you kind of reduce the idea that you're going to end up with a really, really big PD award on a single case, because you're going to be able to break it down into different body parts and into different claims, actually, into different claims of injury itself. Sometimes there's not going to be a quick solution, and sometimes there's simply nothing you're going to be able to do about that because of the particular types of injuries that individuals have. The best thing to do is to get down what is it that they're actually impaired from doing. So what is it that they can do? What is it that they can't do? Making sure that that goes to the doctor, making sure that the doctor is able to generate a report that is comprehensive and that takes into account the factual situations and meets all of the different requirements to be substantial medical evidence. But very important to read not only what the doctor's conclusions are, but you flip to the end of the QME report and see what happened. You got to go through the whole story. You got to see, what kind of information did we get from the applicant? What kind of information did they get from the medical records? Prior, things like, prior injuries may come into play, and things like that may have an impact on a particular case and may explain away why the ADLs are worse, might change apportionment. So, you may end up being able to balance some of this out, even if you end up in an addition situation, if we can change what the apportionment is going to be on the case. And because we just always like to emphasize that the sub rosa is really the best way to deal with this particular type of issue, because it really will show what the individual's activities of daily living will be in particular case. I'm not sure that if we have any more questions. I know I went by this slide real quick while answering the question, but
We do.
Oh, go ahead. I'm sorry.
Okay, sure. One question we have is, are there specific body parts that you find are more likely to involve Kite applications, or are there some injuries that you find where Kite tends to apply more?
Yes, and we do tend to see them more, and it may be because of the ease of actually doing it, given what Kite itself was, which was two hip injuries. So a hip injury on each side. So that's usually where we would end up seeing it, is where you have a hip injured on one side and then a hip injured on the other side, and knee on one side and knee on the other, and the shoulders. So that, especially in my experience, has been where you have seen this doctrine applied quite a bit, is where the individual has two of these particular body parts, would normally use one to attempt to compensate, and now can't compensate because of the underlying injury. And I think that will change. And I know that essentially the Vigil case, which has been out, which has the two different methods that can be used, whether there's an overlap in the ADLs that are being impacted, or whether if there is an overlap, if that is accentuating or intensifying the effect on the individual. I think that because that decision is only about 10 months old, we probably haven't seen it come through as much as we will, but I think that we'll probably end up in situations where we have no overlap a lot, and then we end up having some kind of addition that is being made. So I would expect some of the things that had been resolved in cases 10 years ago where they said there's no overlap but also no substantial medical evidence, those may end up getting re-litigated. We may end up seeing that, and we may end up, of course, and then with another opinion from the WCAB that will then kind of maybe have to re-clarify what that means. Because at first blush, especially when that case came out, it was a bit strange, because it talked about if it doesn't, or if your injuries don't overlap on the impact of the ADLs, then you can add, and also if they overlap, then you can add. You kind of like, wait a minute, hold on, what are you talking about here? But it's just the specific conditions in which they either do affect or don't affect. So, but I would expect some kind of clarification to happen on that at some point. But
sure. And could you also talk a little bit about how you handle or how apportionment is handled when Kite is applied? Does it affect the final rating differently?
Well, because if you do a rating string out in and of itself, so if you do a rating for the back, let's say, that rating will have the impairment level in it, everything like that, adjusts for age and occupation, but it also adjusts for apportionment that will exist in that particular case, and then you'll get a final number. And that's your permanent disability for your lumbar spine. And then you have a C-spine injury that goes along with that, and it has a different level of apportionment, say because the individual already had a prior neck injury, and so there's a bunch of additional apportionment there. That rating string then itself will end up having a number that will come out after apportionment, and now you've got a lumbar permanent disability rating, and you've got a cervical spine permanent disability rating. And then those are just normally put through the combined value charts unless there is going to be some reason to add them together. And then that's where that comes in. So the apportionment is coming in earlier, but the apportionment coming in earlier can really offset any kind of addition that you end up going through when you look at the combined values chart itself. Because when you look at the chart, unless the numbers get particularly high, they're very close to addition to begin with anyway. So when you are looking at doing something that has, is 15% impairment and 7% impairment, and use the combined value chart, it comes out at 21. If you have an applicant attorney that's arguing for addition, that would come out at 22. And the juice kind of isn't worth the squeeze there. So it is when the injuries cause higher disability and higher impairment, that's where adding becomes better than combining. But those are also the kind of cases where you're likely to find some apportionment, because it's unlikely that as the injury is getting worse and worse and worse, that only came from this one particular injury. So that's why apportionment is good, because it helps keep the permanent disability down, which really disincentivizes the idea of, hey, let's go through a whole cross-examination or work really hard just to try to get that one extra point of permanent disability. So I would say that apportionment is something that can help kind of keep this under control to a certain extent.
All right, great. Thank you for that. I think that's all the questions we have time for, Tammy, unless you think we can sneak one more in.
I think we're good unless you have one you want to present. We have about 3 minutes.
All right. Well, we'll make this the last one if that's okay, Zane. So obviously we see applicants' attorneys have been, including questions about Kite and Vigil and now Vigil in their interrogatories. Is there anything that you have been doing specifically in the interrogatories since the Vigil case came out?
Well, if they're simply asking the doctor if that case will apply, then you are almost guaranteed to end up in a cross-examination, because it's going to be very difficult for the doctor to hit all the points that they have to hit, because Vigil's not giving them the whole picture of the law that they have to follow. If you're going to also do an interrogatory, or try to counter what the applicant attorney is doing, you have to lay out what all of the law is for the doctor, and sometimes that's a bit easier to do during a cross-examination to try to tell the doctor, okay, what particular facts did you have on this, instead of, hey, doctor, is there overlap in the ADLs or is there no overlap in the ADLs? And they keep it very simple, and then the doctor answers something very simply. They may have answered the question, but you still have to go back to that substantial medical evidence portion. You still have to go back to the fact that they have to end up coming forward with something that explains the why. So the how and the why, we talked about that a lot in a bunch of these different cases.
Right.
But yeah, the explanation as to why it is that is being used. I think that is something that is going to be a little bit easier to do in sort of a longer joint letter. And it's not going to be something that, if you get those little one paragraph things that applicant attorneys send where they say, please review the Kite and Vigil case and advise if you should add. That's almost guaranteed that the doctor is not going to give you what's going to be needed. If he doesn't give them what they need, then they'll cross-examine him. And if he does say yes, he's not going to have justified it. So now the defense is going to be doing their cross-examination.
Okay. Thank you guys for all the fantastic questions today. Thank you so much, Zane. Thank you, Maya. And thank you all for joining us. Take care, everybody.